learned advocates. The moment I entered this hall, I felt I have come back to the Bangalore bar, my bar. I was feeling very, very comfortable and at ease and at home. Today we have in our midst Mr. K. N. Kumar, Editor-in-Chief of Deccan Herald and Rajavani newspapers. There are many learned senior advocates. Raghvendra has come all the way from Delhi. Sriranga is here. So many, if I start, the whole speech will be full of names whom I know. So I will just restrict. Even Basuraj Bar Council member is here. Aravind Kamath, learned Additional Solicitor General. Mr. Shanti Bhushan, learned Deputy Solicitor General. All my learned advocates. Mr. Ramaswamy, former Additional Chief Secretary, he is here. He is standing. May I request any youngster to make way for him to occupy a seat. I think his son would be the ideal person to give him a seat. Mr. Raghavan said in his introductory speech that he had met me 2 months back and requested me to deliver the first lecture of the Gopi Vallabha Iyengar Memorial Lecture Series. The moment he said, I said, I will come. And before that I asked him what is the subject. When he said the subject would be liberty of the press and restraint, a balancing act, you will have to speak on this subject. I readily agreed for 2 reasons, which I did not disclose to him on that day, and I would like to share it from this dais. Number 1, when I got married in the year 1990, Justice Nittur Srinivas Rao had attended my wedding. So my father introduced him and he said he is a young budding lawyer, so you take the blessings of Justice Nittur Srinivas Rao. So I asked him in the reception, so who is the best colleague you had, junior you had? Immediately he said, Mr. Justice Gopi Vallabha Iyengar. So that was the first reason why I agreed. The second one was, one day I accidentally saw my father's passport. His occupation was written as journalist. So I said, now you are not a journalist, but you are in the profession. He was in cooperative movement. At that time he was the chairman of National Cooperative Housing Federation, New Delhi. So I asked him then, how come you are written as journalism? He said, I said, you please change it. He said, no, till my last breath, my profession will remain as a journalist. The 2 reasons which I do not want to take out, that is, it is only 2 persons who can change the course of the country. One is a journalist, another one is advocate. So he said, I have become a journalist, now you should become a lawyer. At that time I was not a lawyer. So that is how he forced me to become a lawyer. And today I am here in your midst, standing as the judge of the Supreme Court of India. Justice Gopi Vallabha Iyengar was a very great man. My senior Mr. S. Nanjun Swami used to always say, if you have to learn not only the etiquettes of how you should behave in the court, how you should conduct the cases, you should also learn how you can be a good human being. If you want to learn, you learn from Justice Gopi Vallabha Iyengar's deeds. This is what he told us. The third time was when I met Mr. Raghavan while we were opposing a matter from my senior's office. He used to fight and fight and fight. So then I asked my senior, sir, who is this, sir? We always fight, sir. He said, no, he is the son of Gopi Vallabha Iyengar. So this is another reason which I said I will not miss this opportunity to be in your midst to share. They said I'll be throwing some light. No, I will not be throwing any light. I'll be sharing my thoughts. Whatever has occurred to me, I'll just share my thoughts. Honorable judges, distinguished members of the bar, academia, esteemed guests, friends from print and electronic media, ladies and gentlemen. It's an honor to stand before you to speak today on a theme that lies at the very core of democratic society. Liberty of the press and restraint. a balancing act. This is not merely a legal question, it is a constitutional conundrum. It is a philosophical paradox, and it is above all a democratic necessity. Let me begin with a deeper invocation, not just from the Constitution, but from our civilization consciousness. In the Mahabharata, when Arjuna stood divided at the battlefield of Kurukshetra, unsure of whether to act or to retreat, Lord Krishna did not silence him. He did not say, "You keep quiet." He did not say, "You hear what I say." He did not say, "Do what I say." On the other hand, he engages Arjuna in a conversation, in a dialogue. He asks Arjuna to ask questions. He shares his thoughts. He encourages introspection. He does not demand blind obedience. He inspires conscious action. This very spirit of speaking, questioning, and enlightening is what the freedom of the press embodies in a modern constitutional state. Our Upanishad tradition teaches us through niti niti, not this and not that, that is truth discovered, through continuous questioning and peeling away of falsehood. The press, in that sense, is the rishi of our times, tasked with the sacred duty of unveiling the truth through fearless inquiry. But that same sacred knowledge, as per our scriptures, were never to be wielded without humility and dharma. In the Shanti Parva of Mahabharata, Bhishma advises Yudhishthira that, quote, "Power without restraint leads to ruin. Wisdom without balance leads to arrogance." Likewise, the press today holds immense power, the power to shape our minds, stir nations, and expose injustice. But that power, like the divine Sudarshan Chakra, must not be wielded in anger, not in ego, not with any other attachments, but with dharma, with a sense of responsibility to the truth and to bring the truth to the people. Therefore, the liberty and restraint must walk hand in hand, not in conflict, but in constitutional conversation. Today, I shall walk you through this tightrope with 6 broad themes. Number 1, freedom of speech and the role of the press. 2, constitutional bars and liberties. 3, landmark Supreme Court judgments. 4, the constitutional morality of free press. 5, the balancing act in practice. And 6 is my conclusion, reaffirming the 4th pillar. And when I said 6 topics, please don't get scared that it may take long time. It will not exceed more than 20 to 25 minutes. The first subject or the first topic which I say is freedom of speech. At the foundation of any liberal democracy lies the freedom to think, to speak, and to dissent. Article 19(1)(a) of our Constitution enshrines the sacred freedom, that is, the right to freedom of speech and expression. The word press does not explicitly appear in Article 19(1)(a) of the Constitution, and it has been judicially accepted that the freedom of the press is a derivative right flowing directly from the freedom of speech. This was firmly articulated in Indian Express newspaper versus Union of India, 1985, 1 SCC, page 641, where the Apex Court noted, I quote, "The freedom of the press is not only valuable for its own sake, but is also essential to the political health of our democracy." Unquote. The press is our collective voice. It informs the citizens, scrutinizes the government, and ignites public debate. It is both sword and a shield, a protector of liberty and a platform for accountability. However, we must remember that the freedom of the press is not absolute. Even Voltaire, the great advocate of free thought, would concede that liberty without responsibility is tyranny in another form. In our ancient Hindu lore, the sages, rishis, were the voices of the people and the conscience of the kings. Or in other words, they were their conscience keepers. They spoke truth to power fearlessly and often at great risk Today, the media is the inheritor of that sacred role. Both sages, but those sages also practiced what is called as mauna or silence when necessary and measured speech when appropriate. Freedom was never divorced from wisdom. In the same vein, press liberty must be accompanied by self-awareness. The tongue may be free, but the intellect must be bound by responsibility. The second chapter which I would like to deal with is constitutional bars and liberties. The framers of our constitution envisioned a responsible liberty, hence the reasonable restrictions under Article 19(2) was envisaged. The state may impose restrictions in the interest of, number 1, sovereignty and integrity of India, 2, security of the state, 3, to maintain the friendly relations with foreign states, 4, public order, 5, decency or morality, 6, contempt of court, 7, defamation, and 8, incitement to an offence. In Ramesh Thapar v. State of Madras, 1950 SC 124, this is this is earlier to the subsequent judgments which define what is public order. The court struck down a state-imposed ban on a journal, holding that unless the restriction directly endangers the public order, it cannot be justified. This early post-constitutional jurisprudence emphasized that public order must have a close nexus with the expression sought to be restrained. The court has since evolved a finely tuned approach to such restrictions, favoring liberty unless the speech crosses into dangerous terrain. Equally relevant is Article 21, the right to life and personal liberty, which sometimes finds itself on the other end of the spectrum, particularly when media trials or sensational journalism impinge upon individual dignity and fair trial. Thus, our constitutional scheme is a careful calibration of liberty with responsibility, not a zero-sum game, but a dynamic equilibrium. In the age of mass communication, press freedom is not just the right to publish, it is the power to shape perception. And with such power comes the burden of dharma, to speak not only freely, but also rightly. Some of the landmark judgments of the apex court, which I would like to deal only about few of them, which define the judicial moments where the apex court walked on the razor edge of liberty and restraint. In Bennett Coleman versus Union of India 72, two Supreme Court cases, page 788, at para 46, this is what the apex court said, I quote, the freedom of speech cannot be abridged on the ground that it may be exercised improperly. Under the misapprehension that it is likely to be misused, it cannot be, the right to freedom of press or freedom of right to free speech cannot be impinged. In Rajgopal versus State of Tamil Nadu, 1994, 6 SCC 632 at paragraph 29, it was observed the contours of privacy versus press freedom. I quote, the right to publish is a part of the freedom of the press, but it is the subject to the right to privacy of the individual. You cannot encroach upon the individual privacy and then claim or take umbrage under the right to free speech. In Sharda, India Real Estate versus CB, 2012, 10 SCC, page 603, at paragraph 49, the court upheld the concept of postponement orders to ensure fair trial rights, striking a balance of media freedom and judicial sanctity. In one of the recent judgments, that is Arnab Goswami versus Union of India, 2020, 14 volume, SCC page 12, it was held in a modern context. The court reiterated that the press must be protected against harassment, but not at the cost of hate speech or communal incitement. These decisions show that the court has not chosen any sides, but upheld the spirit of Article 19(1)A while preserving the dignity of Article 21 and the majesty of justice. The fourth chapter which I would like to deal is with regard to constitutional morality of free press. We now turn to a theme close to my heart, that is constitutional morality. The term constitutional morality was famously elaborated by the Apex Court in Navdeep Singh Johar versus Union of India, 2018, 10 SCC, page 1, where Justice Chandrachud described it as, quote, a pledge to preserve the letter and spirit of the Constitution. In this light, freedom of the press is not merely a legal right, it is a moral duty. It must serve truth over sensation, or public interest over profit. What do you call it, ratings? That should not be the yardstick. And constitutional values over corporate existence or corporate entities or corporate beneficiaries. The real test of the press freedom is not in its ability to criticize governments, but in its encourage to uphold truth when it is inconvenient, to question narratives when they are popular, and to speak for the voiceless when it is unprofitable. But this moral compass must point both ways. Editors, anchors, digital influencers, they are not just voices, they are power holders. And power, as we know, must bow to scrutiny. Free speech is the mantra, not as a weapon. Its purpose is transformation, not provocation. Similarly, the press must not only follow the law, it must uphold its moral spirit. Just as in Bhagavad Gita, Arjuna is told that his actions must arise from Swadharma, his inner code. So too must the media follow its inner dharma, that is journalistic dharma. What are those journalistic dharma? Number 1, seek truth, avoid harm, ensure it serves the public interest, and lastly, be accountable. We must recall that speech is a Shakti, a form of power, and Shakti in our tradition is both creative and destructive. It creates change when misused. It creates change, but when misused, it foments chaos. Hence, the Constitution steps in not to silence, but to moderate or to balance it, like a charioteer directing a wild horse. Now comes the fifth aspect, that is the balancing act in practice. In practice, this balance is neither easy nor mechanical. It must evolve case by case, context by context. It all depends upon the terrain it travels. It takes its shape from the terrain it travels. Well, sometimes downwards, sometimes upwards, sometimes hard terrain. Consider these modern dilemmas. Number 1, media trials before judicial ones. 2, social media virality versus verified journalism. Corporate ownership versus editorial independence. Fake news factories and algorithm-driven outrage. The question is, how do we regulate without stifling? How do we restrain without suppressing? Statutory frameworks like the Press Council Act, Cable Television Network Regulation Act, and IT Act and Rules 2021 provide necessary regulation. But these instruments must themselves pass the test of proportionality as laid down in Modern Dental College of the State of Madhya Pradesh, 2016, 7 SCC 353, and later on in Puttaswamy's case, that is privacy, right to privacy, 2017, 10 SCC, page 1. The four-pronged test of legality, necessity, proportionality, and least destructive means is crucial when dealing with laws that touch freedom of the press. Moreover, self-regulation by media bodies, fact-checking mechanism, ombudsman frameworks, and journalistic ethics charters must form the internal conscience of the media. And with these 5 subjects, I come to the conclusion and say that the press is often called the fourth estate. It is the truth, the first sentinel of liberty, of justice and democracy. The duty of the press is not to protect power, but to provoke thought. And yet, thought must not provoke hatred. Liberty must not descend into anarchy. That is the balancing act we must uphold. Not merely as judges or journalists, but as citizens of a constitutional republic. In the ever-evolving theatre of democracy, the press stands as both sentinel and storyteller, wielding immense power, but equally burdened with profound responsibility. Liberty of the press is not merely a constitutional guarantee, it is the lifeblood of informed public discourse, the conscience of the people, and the mirror held up to power. Yet, with all freedoms, it must walk in tandem with restraint, not imposed by heavy hand of the state, but exercised from within, through ethics, integrity, and a commitment to truth. The challenge lies in the balance between fearless journalism and factual accuracy, between critic and civility, between revelation and responsibility. Restraint in this light is not a limitation but a measure of maturity, not censorship but calibration. In a pluralistic society where voices are many and truths are often contested, the press must be both bold and balanced. As custodian of the Constitution, it is not our role to stifle the press, but neither can we be indifferent to the consequences of its misuse. In this delicate dance between liberty and restraint, it is wisdom, not impulse, that must guide us. Let us remember the strength of democracy is not in the loudness of its voices, but in the harmony of their coexistence. And in this context, the press is the most powerful instrument capable of both cacophony and cadence. May it always choose the latter. Before I conclude, and as I said in the beginning, when my father was very particular to maintain his credentials in his passport, in all his identity as a journalist, I asked him, you give you one strong reason as to why you want to retain this. He said, he was imprisoned in Mysore jail during freedom struggle. So he was inside the jail for about 4 years. So he said, during third year, they were given little liberties. They were getting one lunch from the house. What he was doing is he was working with a press or a newspaper called Sadhvi, which Mr. Kumar must be knowing, that Sadhvi paper was a leading newspaper in Mysore in those days. So he was writing for that newspaper, and the information he used to collect inside the jail from other jail inmates, he was sending it along with the tiffin box, that carrier which he used to get it. And that used to go and reach the press. And one day that they intersected that tiffin box and they found out that he was sending this, and again he was transferred from Mysore jail to Hassan jail. That is where he met Ashok and his father, Hanali Ramaswamy, and they became jailmates. So he said, we never anticipated that we'll get freedom for our country. It is through these writings, through these newspapers, we used to provoke the people to fight for the freedom of the country. And that is one reason where I want to retain this status of being a journalist till my last breath, and he maintained that till his last breath in the year 2007. Journalists, and I say that even advocates are called as social doctors. They are the one who are capable of changing the course of the country. So I appeal to both the learned advocates and the press to go hand in hand and see that our democracy is reinforced with more strength, and we take our country to greater heights. With this, I take leave of you, and I thank Mr. K.G. Raghavan and all his family members for having given me an opportunity to come here and share my few thoughts with the learned members of the bar, learned judges, and all the elite persons who have joined here. Thank you once again. Namaskar. Jai Hind.